Hi, I am Pratim Ranjan Bose, and you are watching Podcast with Pratim, presented by Iravati Research and Communication Center, or IRCC. In this episode, we will discuss Waqf Amendment Bill 2024, introduced by the Narendra Modi government in India. It was tabled in Lok Sabha, that is the lower house of the Parliament, in August 2024, and is cleared by the Joint Parliamentary Committee in January 2025. There is expectation that it will be picked up for implementation in the ensuing session of Parliament. The bill, if translated into law, will amend the Waqf Act 1995 passed by the Congress government in Delhi. The law was last amended in 2013 by a Congress-led coalition government. India's opposition parties, led by Congress and Islamic bodies like the Muslim Law Board, are opposing Waqf Amendment Bill 2024 on the grounds of secularism. I have with me Advocate Joydeep Sen from Calcutta High Court with 25 years of experience in constitutional writ cases and commercial litigation. Welcome, Joydeep.
Thank you. Namaskar to everybody.
Before I ask questions, here is an introduction to the topic. Waqf refers to properties dedicated exclusively for religious or charitable purposes under Islamic law. The importance of today's discussion lies in land. There are Waqf boards in many Islamic or Islam majority countries like Indonesia, Bangladesh, Malaysia, etc. But Indian Waqf Board have the largest. It is the third largest landowner in India after Army and the Indian Railways. The most critical fact is, while landholding by Railways and Army are increasing by inches, Waqf properties are increasing by leaps and bounds. According to one report, in 2009, India's Waqf boards had over 400,000 acres, or roughly 1,500 square kilometers of land. Over the last 15 years, that is between 2009 and 2024, when the amendment bill was tabled, Waqf landholding increased by nearly 2.5 times to 940,000 acres, or 3,800 square kilometers. Just for understanding about the size of the land, this is equivalent to the total area under 6 metro cities in India, that is Delhi, Kolkata, Mumbai, Chennai, Bengaluru, and Hyderabad. Majority of this land are in states like Uttar Pradesh, 27%, West Bengal 9%, Punjab 9%, etc. Obviously, in a densely populated country where industrialization suffers due to land issues, someone is adding his property list by leaps and bounds. But how? Like any other religious trust, someone can donate his property to the Waqf. But no other charitable trust is acquiring properties or adding to their property list at this rate. The mystery lies in a clause, Waqf by user, which is said to be removed under the proposed amendment. According to a report by The Hindu, Congress's deputy leader in Lok Sabha, Gaurav Gogoi, said that nearly half of the total Waqf holdings falls under the definition of Waqf by user. I will now move to Joydeep for the legal explanations. But before that, here is a sound clip of opposition politician explaining Waqf by user to his Muslim audience. The original video footage was telecast on TV.
যে কোনো একটা জায়গায় যদি 20 জন 25 জন 15 জন 5 জন রেগুলারলি নামাজ পড়ে সেটা ওয়াকফ প্রপার্টি বলে ট্রিট করা হবে।
Joydeep, is land grabbing that easy under Waqf by user? Suppose I have an empty piece of land, some few katas or bigas lying idle, and some people starts using it for offering prayers. Can they grab my property under Waqf Act 1995? Muslims are often seen offering prayers in public spaces like roads, rail stations, railway tracks, anywhere. Did they ever claim such properties as Waqf? Prevailing
Yes,
Indian,
actually, yes.
just to add, prevailing Indian laws are biased towards squatters. It takes years to remove encroachments from land. What is the legal recourse available if someone claims my property as Waqf? Over to you.
Yeah, precisely, yes. Under the present uh, law, which is still operative and which is being proposed for amendment by the 2024 amendment bill by the NDA government. Under the existing law, by claiming user for the purpose of Muslim religious purposes, any land can be claimed as Waqf. And so far, your query regarding the legal recourse. Suppose if your property is claimed as a Waqf property, or my property is claimed as a Waqf property by way of user, like some people is offering namaz there, or some people's ancestors were offering namaz there. By this mere claim, a Waqf board can come to a decision that the property is a Waqf property. And you have a very limited recourse to go before the Waqf tribunal, and the decision of the Waqf tribunal will be final. Even the Honorable Supreme Court cannot interfere into this decision. There is only a very limited scope of judicial review. Now, to give a clarity on what is judicial review, I'll give a little more explanation and the system of law that we follow in India in case of general properties. Then it will be easier for the audience to understand where lies the problem. So, under judicial review, the Supreme Court, Honorable Supreme Court, will only see whether the Waqf Tribunal has followed the Waqf Act, provisions of the Waqf Act, to decide that whether a property is Waqf property or not. And the catch is there that the Waqf Act itself is so draconian that it allows the Waqf board to declare any property as Waqf property by saying it is Waqf by user. And please remember one thing, as per this law, once a Waqf, always a Waqf. So I give an illustration. If somebody turns up and files an affidavit before the Waqf board saying that a particular property was used by his ancestors 4 generations back for regularly offering prayer, Islamic prayer, then the board has power on the basis of that affidavit and a survey conducted by the surveyor appointed by the board to declare that property a Waqf property. And once a property is declared as a Waqf property, it is entered into a register of Waqf. You have only 1 year time to challenge that decision. That too before the Waqf tribunal, not before any court of law. And there you have to prove, unlike other laws of India, including other laws governing religious institutions and religious endowments of other communities, Hindu, Sikh, Jain, Parsi, Christians, Buddhist, any other religious denomination in India, they don't have such law, unlike Waqf Act, that where the Waqf board is claiming a property to be Waqf property, the person who is owner or occupier of that property has to go to Waqf tribunal to prove that it is not a Waqf property.
Okay. So, what you mean is that, is it same for other religious trusts?
Absolutely not.
Say
Absolutely not.
there are religious trusts for Sikhs, Jains, etc. There are many religious trusts. So, do they enjoy such impunity? You have to go to only one place.
Absolutely no. If you have time, I'll in 2 minutes I'll explain the Indian legal system and how a right over a property is declared. Before that, I will indicate some trusts acts, some certain laws prevailing in India which govern the religious trusts and endowments of other religious denominations: Hindu, Sikh, Buddhist, Christian. So one is the Indian Trust Act of 1882. The other is Religious Endowment Act of 1863. Then the Charitable and Religious Trust Act of 1920. In southern parts of India, southern states of India, there are certain special laws, state laws, governing the trusts, governing Hindu properties and Hindu institutions. That is Tamil Nadu Hindu Religious and Charitable Endowment Act of 1959, Sikh Gurdwara Prabandhak Committee Act of 1925, Sikh Gurdwara and Religious Endowment Act of 1973, Travancore Cochin Hindu Religious Institutions Act of 1950. These are all laws governing Hindu endowments, Hindu charities, Hindu temples.
You
So,
mentioned about Sikhs as well.
yes, Sikhs also. The Sikh Gurdwara Prabandhak Committee Act and the Sikh Gurdwara and Religious Endowment Act. In all these acts, if suppose a temple committee or a Hindu religious trust or a Sikh Gurdwara claims that a particular land belongs to them, what they have to do is they have to go to court, file a suit for declaration that the land belongs to them, and with all documentary and other evidence, oral evidence, before the court in a civil suit, these Hindu, Sikh, Christian, Buddhist trusts, they have to establish that the land belongs to them.
Okay.
That is the law, common law in our adversarial system of jurisprudence as practiced in India. But unlike all these charitable laws governing the charitable and trusts, charitable endowments and trusts of other religious denominations, so far the Muslim Waqf is concerned, Shia and Sunni, both Waqf, here the Waqf board will declare a property to be a Waqf property. And now the owner or occupier of the property who have been enjoying their property say for 10 generations, they will have to go to the Waqf tribunal and prove that the property is not a Waqf property, it was never used for Islamic religious purposes. So that is absolutely draconian.
Joydeep, a question here. In case of this particular Waqf Act, you said that the tribunal is the first and the last place where I can seek my recourse, assuming
Yes.
I am a non-Muslim,
Yes.
right? And my property is declared Waqf,
Yes.
assuming that, I in good faith allowed some Muslims to offer prayer on my land and they declared it as Waqf. So I'm
Yes.
seeking a recourse here. Now that recourse should be sought before the Waqf tribunal. Now,
Yes.
the tribunal is operating under Islamic law. So this is my first problem, because even if law itself is difficult, so even if we know I don't know how many lawyers are available for Islamic laws. Second problem is that are there non-Muslims, or I mean, what is the composition? I mean, is it all? I mean, I as a Hindu, will I be judged by all Muslims, or there are other communities as well?
No. As far the Waqf board is concerned, under the present law, all the board members has to be Muslims. And Waqf tribunal and the tribunal is also constituted by the Muslims who will sit over the tribunal.
Does this act has any link or bearing to the mushrooming of mosques in last few decades, Joydeep?
I would rather say that I will give a statistics instead of saying instead of being confident about whether this act has led to mushrooming of mosques here, there, and everywhere. I
Not
will
be
give a
directly, may
statistic.
not be. Yeah.
It may not be directly, but this act itself is an instrument, a legally valid instrument of land grabbing. I give an illustration, and I will tell you. I will try to elucidate what are the dangers of Waqf as defined under 1995 Act. Waqf by user. Before that, I'll give a statistics. I have to look into my paper just to give a small statistics.
Yeah,
Before the 1995 Act coming into force, in India there were around 52,000 Waqf properties.
Mhm.
By
Right.
2009,
Mhm.
by 2009, the number rose to 3 lakh registered Waqf properties, from 52 to 3 lakhs. Well,
Mhm.
and so far the land under control of various Waqf boards is concerned. I am reading a report from the Outlook published in this February, 27
Yeah,
February 2020.
I gave you that reference in the introduction that between 2009 and 2024, the amount of land under the Waqf board has gone up by 2.5 times. And this
Yes,
land
8
is
lakh acres. It is 8 lakh acres as per Outlook.
no,
As on
8 lakh is an old figure. So the 2024 bill, if you read, that is at that time, the land was above more than 9 lakh. Okay,
9
9
lakh
lakh
acres.
acres. So I just calculated it, I converted it into square kilometers, and I found that it is equivalent to the total land of all six metro cities in India, under six
Yes,
metro cities in India. So that's huge, huge.
that's
So
huge. That's huge.
back to the topic. What are the key amendments that we are proposing? I understand the walk-up by user will be dropped, and what are the other amendments that the bill is proposing?
There will be a more enlarged scope. There will be a more enlarged scope of challenging any decision of the Waqf board, Waqf tribunal. Now, second is that
What does it
under
mean? Please follow.
that means that it has to be filed. It has to be institutionalized as a suit for claim of land. Now, to
So does it
explain,
mean that I will have more options? I mean, the same do I have to go to the work of tribunal? How
no,
will it be done? Or tribunal
no,
will be an option?
no. I explain this. Suppose somebody, now what happens now? I have to say what happens now to elucidate what will be the post amendment scenario. Now, Waqf board on somebody's application or suo moto can say this land belongs to Waqf. Now you have to run around. The owner of the land has to go to tribunals to prove it is not a Waqf property. Well, and
Okay.
so onus is on the person who is disputing it is a Waqf land.
Right.
But after the amendment, it will so happen that if Waqf board claims a land to be a Waqf land, Waqf board has to prove it is a Waqf property.
Okay. So they have to come up with the proof first.
Yes, the onus of proof will be on Waqf board, just like any other law, any other provisions of law relating to property and land. What is the law in India? That is, if I claim a property to be mine, I will have to prove before court this property is mine.
Right. Right.
For Waqf Act, under Waqf Act 1995, it was just the other way around. Waqf board can claim and take possession of any property, saying it is Waqf. Now, the person whose property is taken under Waqf has to go and prove by negative evidence, which is next to impossible, that it is not a Waqf property and it was never used as a Waqf property for the Islamic purposes. And the most dangerous provision under this 1995 Act is Waqf by user. I'll give you a few live illustrations. In Tamil Nadu, a village and a temple in the village, which is 200, 1200 years old temple, that is before Islam came into India, was claimed as a Waqf property. In Bihar, entire village is claimed as Waqf property. So these things are coming up in newspapers every day. Waqf dispute, you type in Google Waqf dispute, one or other, this sort of news will come up. Now, Waqf by user has another problem which has happened in Surat. there is one house condominium. It's a housing complex, Shiva Shakti Society. It's a condominium. It's a housing complex. One Muslim gentleman purchased a small flat there and declared that flat, his own flat, to be Waqf. Now, what happens when it's a housing society? A person is not only owner of a particular apartment, he is also owner of the entire common areas, common facilities. Now, once this gentleman has declared his flat in the society as a Waqf property, the entire common spaces in the entire condominium, in entire society, housing society, has become Waqf by way of a user. And not only he or his family member, the Muslims of the neighborhood can come and offer namaz in the common areas of that housing society, and that is happening, and that has come up in the newspaper. It is in Surat. The society's name is Shiva Shakti Society. Now, I give an example. Somebody in your condominium or in your housing complex or my housing complex buys a flat, dedicates it to Waqf, declares it as a Waqf and gets it registered with the Waqf board as a Waqf property. Then the entire staircase, rooftop, garden, common area, all the common area, common amenities comes under Waqf by user.
I just a question here. Suppose in one of my a property, now there the flat is is there is a tripartite agreement between the cooperative society and the seller and me, the buyer, right? Tripartite because the flat is the plinth area is mine, but just next to my door, the staircase, the roads inside the society, they all are common. So, now being a member of the society, I am an equity holder. So I have equity over the entire place, the common area.
Yes.
I'm a partner. So in this case, how can the Waqf by user can impact it? Suppose someone purchased a flat and what can happen?
Waqf Act, rights under Waqf Act, which is for the purpose of preservation, advancement of Islam, preservation, maintenance, and advancement and service of Islam and Islamic institutions. This will, as per the preamble of the Waqf Act, it is superseding above any other contractual rights. What right you are speaking of, the tripartite agreement, is a contractual right.
Right.
So that contractual right is in personam among certain persons. But Waqf Act, the rights created under Waqf Act are in rem so far Muslims are concerned. So it becomes a public Waqf by way of user. So your right will be superseded if the property is declared as Waqf by user.
So that's dangerous. That's really dangerous because I mean the contract is an ultimate thing in a civilized society. You have a contract, so someone else has a superseding right. Now, government always had a superseding right for any dispute.
Yes.
Particularly in case of land in India, the government had a superseding right. Suppose I have a house and they decide to build a road, they need to acquire my house, right? So, but here you are saying that someone else has a superseding right on that area, so he can claim a portion of highway as Waqf.
Yes, absolutely. That is exactly what happened. That's why I gave this live example. I'm not giving a hypothetical situation. I'm giving what has exactly happened. And Waqf board has declared the Shiva Shakti Society common area as Waqf area, Waqf property.
Unfortunate situation. So the amendment. So you tell me the other major areas of amendment that the bill proposes.
There are technical.
I saw two areas. I saw one area. One is that the Central Waqf Council and Waqf boards to include non-Muslim members.
Yes,
And
yes,
the bill restricts eligibility of property donation. Suppose I am a Muslim, I want
yes,
to donate my property to the Waqf. Now I have to prove that I was practicing Islam for last 5 years. Now I assume
yes.
I have a faint I mean, this is my hunch that this is somewhere related to avoid the cases of conversion or something. But over to you. I mean, how do you look at these two things? Because there have been many objections and etc.
See, a person, I have not gone into a sociological study as to what will be the impact of this proposed provision so far conversion is concerned. I have looked into the Waqf Act and the proposed bill from absolutely a legal perspective, from a lawyer's point of view. What I find is that other areas where there should be a national Waqf portal, there should be women member incorporated in the board, non-Muslims in the board or the tribunal. These are minor changes. I'm really not gone into. I've really not gone into the object and purpose of the government, the parliament, into making such changes. So I'm not right now competent to comment on that. But so far, the biggest change and sort of a saving clause, I can say, in the amendment for the non-Muslim community in India is that removal of Waqf by user.
Right.
Any
No,
property and any property can be grabbed under the 1995 law by treating it as Waqf by user, and
right. I
no other law governing any other religious denomination or institution in India has such draconian provisions. There are cases where Ranganatha Swami temple in Tamil Nadu, there were encroachment on its lands, and the temple committee is fighting
Ranganathan
cases.
Swami temple means that's in Trichy, probably.
Yes, yes. Some people encroach their land, set up shops and bastis and all. Now the temple committee is fighting a eviction suit and declaration suit for last 8 to 10 years, just like any
Okay.
common litigant, to
Okay.
evict the encroachers. And here, your property being declared by Waqf board as a Waqf property by user, Waqf board will declare you as a encroacher and can send you an eviction notice or ask rent from you. And if you don't vacate the property on receiving an eviction notice, they can go to the collector or magistrate, seek police help, and under the law, police is bound to district administration is bound to provide them police assistance to remove you from the property without any other recourse to law. That was
So
the beauty of Act enacted by
we
Manmohan
right.
Singh, not Manmohan Singh,
It was
PV
Narasimha
Narasimha
Rao
Rao.
government. Narasimha Rao government. And it's interesting because as such, it is very difficult in India to remove encroachers. The cases go on, and it takes a lot of time unless you are a builder and you have some other means and
Yes,
etc.
yes.
It takes a lot of time. But on top of that, I find that it is it is a very serious thing. I mean, someone can simply adopt another technique to supersede all laws. In that case,
Yes,
it will be a short case.
exactly. That's
So
happened.
thanks, Joydeep. Thanks for coming.